which is real estate brokerage, part 2. This unit continues the detailed discussion of agency relationships discussed in Unit 13. We're going to go over following topics: how agencies are created, express versus implied agency, sub-agency, single agency, dual agency, agency disclosure, working with for sale by owner sellers, common agency relationships, the brokers and salesperson authority as agents, termination of agency, bankruptcy effects on contracts. So you're going to do some independent study, go through the slides. I will be reviewing the unit quizzes. And I'll review the unit summary. All right, so an express agency is created by specific authorization from the principal. An implied agency is created by the actions and or statements of the parties. A sub-agent is a person appointed by a broker, like an agent, right? This is a sub-agent. They're appointed by a broker under authority granted by a client to perform functions on the client's behalf. There's 3 scenarios that might create a sub-agency are delegating authority to another designated broker during the delegating broker's temporary absence. A vacationing salesperson authorizes a licensee from another company to handle a transaction. A licensee changes brokerages companies but continues to work on transactions. So a single agency exists when only one party is represented. In new home sales, the on-site licensee represents the seller as a single agent. When one or more licensees in a brokerage firm represents both the buyer and seller in the same transaction, a dual agency is created. When a dual agency exists, the licensees must obtain the informed consent of both parties. Written agency disclosure should be made at first substantive discussion with the client. It is possible to accept compensation from a for sale by owner seller, but not represent them. A power of attorney creates an agency relationship between the client and their attorney in fact. Powers of attorney may be specific or general. A durable power of attorney extends the agency in the event of the client's incompetence. Under a listing or buyer-broker agreement, the broker is a special agent with a limited authority. Under a property management agreement, the broker is the principal's general agent and has broad powers. Imputed notice means that notice given to the client is notice to the client. Vicarious liability is the concept that a principal is liable for the acts of their agent. Errors and omissions insurance insures licensees against misrepresentation or material facts the licensee failed to disclose. General liability insurance insures the brokerage or licensee against claims when a third party is injured. Umbrella insurance is extra liability insurance designed to protect the insured from major claims or lawsuits. Broker tail insurance is errors and omissions coverage that protects a broker after leaving a company. So it's called broker tail insurance. A salesperson or associate broker always represents their broker and is the broker's general agent. An employee is a person whose work is dictated by the employer. An employer may not control how an independent contractor completes a project. An agency may be terminated by performance, mutual agreement, expiration of term, revocation of the destruction of property, bankruptcy of the principal, death, or serious incapacity of the principal or agent. Chapter 7, bankruptcy is liquidation. Chapter 11, bankruptcy is a business reorganization. Chapter 13, bankruptcy is a wage earner reorganization. Bankruptcy may have the effect of terminating or extending a contract, stall a foreclosure, or cause a debtor to default under a contract. So let's go over. So, which of the following is correct in relation to salespersons who are treated as independent contractors by the broker? So it is Delta. The broker and salesperson must enter into a written independent contractor agreement. So again, which of the following is correct in relation to salesperson who are treated as independent contractors by the broker? The broker and salesperson must enter into a written independent contractor agreement. True. So workman's comp, no. Federal income tax withheld, no. The salesperson will receive W-2, no. A durable power of attorney, what? Alpha extends the power of attorney past its expiration in the event the principal becomes incompetent. So that's called a durable power of attorney. It extends the power of attorney past its expiration in the event the principal becomes incompetent. So what's interesting is that you can have a power of attorney that's for like 6 months, right? But a durable power of attorney extends the power of attorney past its expiration in the event the principal becomes incompetent. So extends beyond the death of the principal? No. Never expires? No. So power of attorneys, they expire, right? Gives the attorney, in fact, specific power to sell all of the principal's real estate. So no. So number 3, a special agent can do all the following except what? Except represent the principal in all real estate transactions. A special agent can do all the following except represent the principal in all real estate transactions. So can they sell land? Yes. Can they find a ready, willing, and able buyer? Yes. Can they represent the principal in a specific real estate transaction? Yes. Can they represent the principal in all real estate transactions? No. The agent shows several houses to a buyer and tells him that one house is the best investment for him. What type of agency may the salesperson be creating? Bravo, implied agency. All right, so implied agency, it says where the agent shows several houses to a buyer and tells him that one house is the best investment for him. So what type of agency may this salesperson be creating? General agency. I'm sorry, implied agency. So you can create agency just by talking to somebody, verbal, right? And that's called an implied agency. Express agency, no. General agency, no. Specific agency, no. An unrepresented seller compensation agreement is commonly used in what type of transaction? Charlie, for sale by owner. So again, an unrepresented seller compensation agreement is commonly used in what type of transaction? For sale by owner. So for sale by owner is an unrepresented seller compensation agreement. That's what's commonly used in that type of transaction. Unrepresented seller compensation. What about, is it dual agency? No. New home sales? No. Exclusive agency listing? No. So in a for sale by owner, they're unrepresented, right? It's called an unrepresented seller compensation agreement. And that's, you still get paid um, as a, from a for sale by owner, and it's called an unrepresented seller compensation agreement. If the sellers were to die during the term of the listing, the what? Charlie, the listing is terminated. So if the sellers, right, they're selling their house and they die during the term of the listing, can the agent just sell the house still to a buyer? No. Right? The listing is terminated, like the Terminator, right? When they die, they cannot act anymore, right? So that listing is null and void and terminated. So A says listing is binding on their heirs. No, it doesn't fall on theirs. The listing is terminated, but the broker is entitled to a commission. No, no commission is paid out. Broker can collect full commission. No. It says if the sellers were to die during the term of the listing. Now they didn't enter escrow, right? So it was just the listing, right? Nobody has accepted or any offers yet. They didn't enter into escrow yet, so but it's just the listing is terminated. What authorizes an individual to sign or execute a contract on behalf of another? Charlie, power of attorney. So when you have a power of attorney, you can sign on someone else's behalf. Attorney at law? No. Attorney at fact? No. Specific agency? No. Chapter 13, bankruptcy, provides relief for wage earners. Right? There's chapter 7, chapter 11, chapter 13. Chapter 13 provides relief for wage earners. Does not require a trustee be appointed? No. Requires liquidation of assets? No. Lists the automatic stay? No. It provides relief for wage earners. Chapter 13. A constitutional right to eliminate debt is bankruptcy. So eminent domain, no. Dedication, no. Adhesion, no. So bankruptcy is a constitutional right to eliminate debt. You have a right to eliminate your debt called bankruptcy. So if you have too much debt, you can file bankruptcy to eliminate that debt. A person who hires another individual to act for him is called the principal, right? So a principal is a person who hires another individual to act for him, right? So a principal is like the seller. Principal hires an agent to sell their house. So they're called the principal, right? It's a person who hires another individual to act for him or her, and they're called the principal. The agent is the realtor, the listing agent, who's going to be doing the acting, right? So a person who hires another individual to act for him is called the principal. Is it the agent? No. Fiduciary? No. Attorney in fact? No. An agent represents a buyer who wants to make an offer on a for sale by owner property. During the negotiations, the agent enters into a listing agreement with the seller. What has been created? Dual agency. Again, so an agent represents a buyer who wants to make an offer on a for sale by owner property. During the negotiation, the agent enters into a listing agreement with the seller. So now that agent is representing the seller and representing the buyer. What has been created? Dual agency, because that agent is now representing the buyer and the seller. So single agency, no. Unrepresented seller compensation agreement, no. So all of the following situations would legally terminate a listing except what? So it would be alpha, death of the listing salesperson. That would not terminate a listing. Why? Because the listing was never with the agent. It's with the seller and the brokerage. So the salesperson represents the broker, represents the brokerage. So if the salesperson dies, they basically replace with a different agent with that same brokerage. So the seller, the listing agreement is with the seller and the brokerage, not the individual salesperson. So B, revocation by the seller. So if the seller revokes it, that would generally terminate the listing. C, revocation by the broker unilaterally. They can terminate the listing. D, if the seller goes insane, that can typically terminate the listing because they have to be competent, right? Under a typical listing agreement, what is the agency created between the broker and the seller? It is alpha, special agency. That is what we call when you go into a contract between the broker and the seller, you have special agency. Universal agency, no. General agency, no. Ostensible agency, no. Special agency. In the sale of new homes in a subdivision, the on-site real estate licensee typically represents all of the following persons except what? It is the buyer, alpha. So is it the builder? No. Seller? No. Seller's broker? No. So again, the buyer in the sale of a new home in a subdivision, the on-site real estate licensee typically represents all of the following people except who? The buyer. I mean, if you ever go to a new home, new homes in the subdivision, there's an agent. That agent is trying to find buyers. So they're going to represent the builder and the seller's broker. They're not going to represent the buyer. They are looking for the buyer's agent, the buyer's, the buyer's agent. So in the sale of new homes subdivision, the on-site real estate licensee typically represents all the following except the buyer. The agency of a real estate broker with the client is established by expressed contract. So express contract is when the agency of a real estate broker with a client is established. The agency of a real estate broker with a client is established. It's called express contract. Is it implied contract? No. Estoppel? No. Ratification? No. All the following are situations in which a sub-agency is created except what? So it is delta. It's when a broker from one person, brokerage company, takes a listing on a family member's house. So that's a situation where sub-agency is created, except that one. So let's go to alpha. Situations in which sub-agency is created, except what? So A, delegating authority to another designated broker during the delegating broker's temporary absence. That would be a situation in which subagency is created. Vacation an associate broker authorized licensee from another company to handle a transaction. Yep, that subagency is created. Salesperson changes brokerages companies but continues to work on transactions entered into while working on the former brokerage. That's where subagency is created. A broker from one brokerage company takes a listing on a family member's house. No sub-agency is created. So A, B, C, except D. All right, if one agent is exclusively representing the seller and a buyer's broker brings the buyer and seller together, it would be a single agency, alpha. So if one single agency is one agent is exclusively representing the seller, and a buyer's broker brings the buyer and seller together, and a buyer's broker brings the buyer and seller together, it would be a single agency. Okay. Would it be a dual agency? No. Universal agency? No. Ratified agency? No. Which of the following requires informed consent of the parties? Delta, dual agency. So which of the following requires informed consent of the parties? So if you're doing dual agency, you're representing both parties, you need dual, right, consent, informed consent of the parties. Single agency, no. Sub-agency, no. Fiduciary, no. But it requires informed consent if you're doing dual agency. The idea that principals may be held liable for the acts of their agents is alpha, vicarious liability. So vicarious liability is the idea that a principal, right, the person hiring their agent, they are now liable for the acts of their agents. So that's called vicarious liability. Is it imputed notice? No. Fiduciary duty? No. Caveat emptor? No. So vicarious liability is when the principal has liability for their agents. Which of these situations would most likely allow the seller to terminate a listing without creating liability to the seller? It would be alpha. The broker failed to market the property as promised. So, if your broker's like, I'm going to market it and get you offered tomorrow, then that would most likely allow the seller to terminate a listing without creating liability for the seller. So what if it's the supply of buyers is at a seasonal low? No, you can't argue. There's no buyers. The seller no longer wants to sell. That has happened a lot sometimes, not a lot, but so that's happened, or seller has seller's remorse or whatever. But that doesn't terminate the contract. That doesn't terminate the listing. They signed the listing agreement, so it keeps going. But if they have another valid reason, then like say broker fails to market the property as promised, then they can terminate the listing. The agent failed to follow instructions to ignore material defects. So no. So if your agent failed to follow instructions to ignore material defects, it still doesn't terminate the listing without creating liability for the seller. The agent is allowed to accept or reject an offer made on the principal's property when the Delta agent has written authority. All right, so the agent is allowed to accept or reject an offer made on the principal's property when the agent has written authority. So if the agent wants to say yes or no on contracts, you need to have written authority. A, offers ridiculously high, no. Offers ridiculously low, no. Owner is out of town, no. So you need to have written authority to act on those offers. The concept that information given to a client's agent has been given to the client is known as imputed notice. So imputed notice, delta, right, is a concept. So vicarious liability, that's when the principal has liability for the agent. Imputed notice is where the concept that information given to a client's agent has been given to the client. Right? So imputed notice, basically like they're imputing that notice, you're imputing information, you're getting information to your client. Right? The client's agent has that information of the client. That's imputed notice. They have that imputed notice. They're getting that, given that client's agent has been given to the client. Right? Concept of information given to the client's agent. So is that caveat emptor? No. Respondent superior? No. Vicarious liability? No. A property is listed for sale, and before expiration of the listing, the principal is declared bankrupt. The listing is terminated. Alpha, right? So property, they listed it for sale, and before the listing expires, the principal is bankrupt. So what happens to the listing? It's going to be terminated now. So is the listing not affected? No. Subjected to court review? No. Is it transferred to the trustee? No. It is terminated, right? Why? Because the seller is now bankrupt. So there's no, the seller has to be able to pay fees to the agents, to the title company. So property is listed for sale, and before expiration of the listing, the principals is declared bankrupt. The seller, they have no money, or they have no debt, So listing becomes terminated. If a salesperson representing a buyer works in one office and a broker representing a seller works in a branch office under the same designated broker, the buyer's agent can what? Delta informed the buyer that they should get an inspection. 24, if a salesperson representing a buyer works in one office and a broker representing a seller works in a branch office under the same designated broker, the buyer's agent can what? Delta inform the buyer that they should get an inspection. So let's look at option A. Let the buyer know that the seller is going through a divorce? No. Suggest an offer price to the buyer? No. Tell the prospective buyer that the seller is willing to take $10,000 less than the listed price? No. So the best answer you should take is Delta D. Inform the buyer that they can get an inspection. All right, number 25. A person authorized to act on someone else's behalf and perform various business transactions is a Bravo general agent. So a general agent is a person authorized to act on someone else's behalf and perform various business transactions. So again, a general agent is a person authorized to act on someone else's behalf and perform various business transactions. Is it a special agent? No. Ostensible agent? No. Ratified agent? No. 26. Which of the following is not a type of insurance that protects a real estate broker from liability? Bravo. It is B, mortgage insurance. So that mortgage insurance does not a type of insurance that protects a real estate broker from liability. So let's look at alpha. Errors and omissions insurance, E&O insurance. Yes, that is a type of insurance that protects a real estate broker from liability. Uh, General liability insurance. Yes. Umbrella insurance. Yes. The agency created between the broker and seller in a signed listing is a alpha expressed agency. Is it implied agency? No. Agency of necessity? No. Ostensible agency? No. So alpha expressed agency, that's when you have agency that's created between the real estate broker and your seller. And it's an assigned listing that's called expressed agency. And it's different from general agent. So a general agent is going to be a person authorized to act on someone else's behalf and perform various business transactions. But a expressed agency is when you have agency that's created between the broker and the seller in an assigned listing. Under a typical listing agreement, what is the agency created between the broker and the seller? It is alpha. Correct answer is A, special agency. So this is under a typical listing agreement. The agency that's created between the broker and the seller is what we call a special agency. So is it a universal agency? No. Is it a general agency? No. Is it ostensible agency? No. It is a special agency that's created between a typical listing agreement between the broker and the seller. What's the concept that information given to a client's agent has been given to the client is known as imputed notice, delta. So it's imputed notice because that notice is given to the client's agent and that's also been given to the client. All the following situations would legally terminate a listing except alpha, death of the listing salesperson. Why? Because the the listing is with the brokerage and the seller. It's not necessarily with the salesperson. An unrepresented seller compensation agreement is commonly used in what type of transaction? It's going to be a for sale by owner. All right, so next up, we're going to cover Unit 15, which is dealing with commission, math, and purchase contracts for Part 1. Let's go over Unit 15. We're going to talk about commission, math, and purchase contracts, Part 1. All right, so this unit, we're going to go over the ability to calculate commissions on a transaction is elementary but essential for every real estate broker, as is the need to understand the elements that go into preparing a purchase agreement between buyers and sellers. This unit will review commission calculations and discuss the offer, counter offer process in negotiating purchase agreements. Okay, so you're going to need to do some independent study I'm going to be going over the unit quiz. Okay, so here's the unit summary. So some of the key points you need to remember is a letter of intent expresses the party's intentions to invest in, buy, or develop a property without creating a binding obligation. All right, so it's a letter of intent. And it's going to express the party's intention to invest in, buy, or develop a property without creating a binding obligation. That's what's called a letter of intent. An offer is not a contract, right? So you get many offers. You don't have to accept them. You get so much time to accept or reject, but it's not a contract. It is an invitation to enter into a contract. That's what we call an offer. When a licensee buys, sells, or rents a property for themselves, they must disclose their license status, right? Any change in an offer is a counteroffer. Upon acceptance of an offer and written communication of the acceptance to the offeror, the agreement becomes a binding contract. After acceptance, the buyer is said to have equitable title and the contract is executory until closing takes place. A purchase agreement is binding on the parties' heirs. Purchase agreements and leases are generally assignable unless prohibited in the contract. Or nominee is a term used to indicate that the buyer or lessee may name another person who will complete the transaction. A backup offer is an offer submitted to a seller who's already under contract to sell the property. If the seller accepts a backup offer, the acceptance should be contingent on the written termination of the original contract. In Arizona, earnest money is usually handled by the buyer's broker. Arizona law requires the form of earnest money be stated in the contract. Arizona law requires that, unless otherwise agreed to in writing, the broker must place earnest money in a trust account or in escrow immediately. Commingling is mixing client funds with the broker's business or personal account. Conversion of funds occurs when the agent uses trust funds for his or her own use. And in new home sales, the contract usually states the earnest money will not be placed in escrow. All right, let's go to number one. If the buyer in a purchase agreement were killed in an auto accident before closing, what happens? Bravo, it's B. The purchase agreement is binding on their estate, right? So look at A. The purchase agreement is null and void. No. C says the purchase agreement is voidable by their estate. No. Their insurance company is bound to the contract. No. So B, the purchase agreement is binding on their estate. So buyers in a purchase agreement were killed in an auto accident before they closed. The purchase agreement is still going to be binding on their estate, right? So still going to go through, sellers still want their money. If it's in escrow, they're about to close, right? It's going to be on their estate. Between the time the purchase contract is signed by the buyer and seller and title changes hands, the contract is alpha executory, right? So executory is between the time the purchase contract is signed, the buyer and seller, and title changes hands. The contract is executory. So there's a gap in time between the time the purchase contract is signed and the buyer and seller and title changes hands. Right? It's still executory. Is it B, executed? No. Is it voidable? No. Is it unenforceable? No. A property is listed for $45,000. Broker M brings a buyer who offers $44,000. The seller counters with $44,500, but the counter offer is not accepted by the buyer. Later, the seller decides to accept the $44,000 offer. Which of the following statements is correct? D, there is no contract in effect. Right? So A says broker M is entitled to a commission. No. There is a contract in effect for 44.5. No. There's a contract in effect for 44K. No. It's D. There's no contract in effect because. So let's go again. Property they listed for 45,000. They got an offer for 44. The seller counted for 44.5. The buyer didn't accept that. So that's the end of that. Just because the seller wants to accept an old contract for 44K, that was null and void once they submitted a counteroffer for 44.5. Okay. So that's how that works. Number 4, when a buyer's interest in a purchase contract is assigned to a third party, the seller's permission is what? Delta may be required. So when a buyer's interest in a purchase contract is assigned to a third party, the seller's permission may be required, right? When a buyer's interest in a purchase contract is assigned to a third party, the seller's permission may be required. Alpha is always required? No. Is never required? No. Must be obtained at a time of listing the property? No. Number 5, if a verbal offer is made on a property and 2 hours later a different written offer is made, the listing agent must what? Alpha, submit both offers. So again, remember that all offers have to be submitted, verbal or written, doesn't matter. So if a verbal offer is made on a property and 2 hours later a different written offer is made, the listing agent should present all offers. So B says present only the written offer. No. Present which one is higher? No. Present only the verbal offer. No. An offer to purchase is a what? Bravo. It is expression of intent to enter a contract. So an offer to purchase is an expression of intent to enter a contract. Is it a unilateral contract? No. Is it a bilateral contract to purchase? No. Is it a binding on the offeror? No. So it's offer it's an expression of intent to enter a contract. Number 7, the amount of the earnest money is determined by the by the buyer and the seller. So this is the amount of the earnest money that's determined by the buyer and seller. Now, realtors will usually say it's like 1%, of the purchase price on giving some advice. But usually earnest money would be determined by the buyer and seller. So is it determined by the buyer? No. Seller? No. Broker? No. It's buyer and seller. So sometimes a buyer will put down like $500 and the seller won't accept it. And they want, $5,000. So that is negotiable between the two. And the earnest money is just it's it's good faith money to make sure the deal goes through. And sometimes the earnest money needs to be higher for the seller to accept it. So, number 8, S makes an offer to purchase a home listed by a broker, but the seller is not available until Wednesday. On Tuesday, S wishes to withdraw the offer. Which of the following statements is correct? It is C. The broker must return the deposit and the offer. So again, S is going to make an offer to purchase a home listed by a broker, but the seller is not available until Wednesday. On Tuesday, S wishes to withdraw the offer. And so basically, the broker must return the deposit and offer. So if the listing agent is not even going to be available till Wednesday and they submitted their offer, and Tuesday they want to cancel the offer, perfectly fine. Broker needs to return the deposit and the offer. So A says S cannot do this as S has signed the contract. No. S must forfeit the earnest money. No. The broker should tell S the offer has been accepted. No. Earnest money is normally held where? Answer is bravo. By the buyer's agent's broker, right? Typically, the buyer's agent's broker is where earnest money is normally held. But actually, a step further from that, typically in escrow, right? Earnest money is going to be held with escrow. Usually, the broker doesn't handle it, but if anybody is going to have earnest money, it'll be the buyer's agent's broker, and they'll put it in with the title company in escrow. So A says by the listing agent's broker. No, only in a broker's trust account. It's no, but it would be if it was a property management account. Then you would put the earnest money in that trust account. D says by the seller. Definitely not. Number 10, a seller accepts a purchase contract but makes a minor modification in the terms. The purchaser is what? Delta, relieved of the original offer. So a seller accepts a purchase contract but makes a minor modification in the terms. The purchaser is relieved of the original offer. So basically, the offer is null and void when you change the terms like that. So if you want to get the buyer to accept the new offer, you need to submit that counteroffer with those terms that you just adjusted, and get them to sign off on basically a brand new contract with just that addendum added. So A says bound by the original offer. No, that original offer, if you change the terms, the original offer is off the table now. B, bound to accept the changes. No, they don't have to accept the changes. Bound by the agent's decision. No, nothing's bound by the agent's decision. D is relieved of the original offer. Number 11, if the real buyer of a property wants to remain anonymous, what term should be used after the name of the buyer stated in the purchase contract? It is B, or nominee, right? So if the real buyer of a property wants to remain anonymous, what term should be used after the name of the buyer stated in the purchase contract? You could write or nominee. So that would make the buyer anonymous. If the real buyer wants to remain anonymous, you just write in there or nominee, and that's going to keep the buyer anonymous in that purchase contract. So A says You write or principal, no. Or assigner, no. Or nominer, no. You write or nominee, and that's is going to give the purchaser, the buyer, keeps their name anonymous. Not everyone wants to have their name as the buyer. Number 12, in Arizona, a purchase agreement prepared by a licensee must contain which of the following provisions? It is Delta D. The form of earnest money must be stated. So in Arizona, a purchase agreement prepared by a licensee must contain which of the following provisions? The form of earnest money must be stated. That's one of the provisions. So A says the manner in which the buyer is taking title. No. The party signature must be notarized. No. Prorations will always be done as of the date of closing. No. That's the form of earnest money. So in the purchase contract, it usually says if you're going to do a wire transfer or a cash or a cashier's check to submit the earnest money to the title company, and they'll hold it in escrow. Number 13, the seller of a property that has been listed for many months is out of town for an extended period of time, and a full price offer is made by a buyer. The listing broker should what? Answer is bravo. The listing broker may not accept the offer, right? So again, the seller of a property that has been listed for many months is out of town for an extended period of time, and a full price offer is made by a buyer. The listing broker may not accept the offer. Why? They have to kick it over to the seller. It doesn't matter how long he's out of town. The seller has to make the decision, unless it's in writing. Here I didn't say that, but the listing agent cannot just accept the offer, right? You have to make sure you get the sellers to make that judgment. A says may accept the offer because the agent is the seller's attorney in fact. No. C is may accept the offer because it is a full price offer. No. May accept the offer based on the broker's fiduciary duties. No. So it is bravo. B. In the event that a property was damaged by fire prior to closing, what happens? It is C, right? Risk of loss would be upon the seller. So again, in the event that a property was damaged by fire prior to closing. So before closing, who owns it? The seller. So whose fault is it? The seller. So who's the risk of loss? The seller, right? They didn't close yet, so it's still the seller's property. So um, so it's never a good idea to let the buyer to move in early, because until it closes, until the title transfers over, do not let your buyer move in there early. A says buyer would have to buy the property. No. Risk of loss would be upon the buyer. No. The risk of loss would be upon the seller. Buyer must forfeit the earnest money. No. Which of the following expresses the party's desire to negotiate a sale or lease, but is usually a non-binding agreement? So non-binding agreement. It is Delta, letter of intent. So which of the following expresses the party's desire to negotiate a sale or lease, but usually a non-binding agreement? That's a letter of intent. Is it an option? No. A right of first refusal? No. Purchase contract? No. So because a purchase contract is binding, so a letter of intent is not binding. So 15 is D. Number 16. When a purchase offer indicates that a nominee may be the person closing the purchase, what happens? It is Charlie C. The seller may require disclosure of the nominee to determine the nominee's ability to close on the purchase. So the seller may require disclosure of the nominee to determine the nominee's ability to close on the purchase. That's perfectly fine. You want to make sure the buyer has the ability, the material fact of the financial ability to close, right? You don't want to keep extending this. Maybe they can't close and they have to extend it. So you want to make sure. So when a purchase offer indicates that a nominee may be the person closing the purchase, the seller may require disclosure of the nominee to determine the nominee's ability to close on the purchase. So A says, seller does not have the right to approve the nominee. No. The buyer must disclose the nominee within 10 days of a seller's acceptance. No. The named buyer will forfeit earnest money if financing is not available. No. Number 17, Pete mails an offer to John on March 4th to purchase John's property. The offer states John has until no later than March 10th to notify Pete of acceptance. John accepts the offer immediately, mails it back to Pete, but due to postal strike, Pete does not receive the acceptance by March 10th. At this point, what happens? It is Delta D. There is a valid contract. So again, Pete mails an offer to John on March 4th to purchase John's property. The offer states that John has until no later than March 10th to notify Pete of acceptance. John accepts the offer immediately and mails it back to Pete, but due to post strike, Pete does not receive until March 10th, which is still within the time frame. So there's still a valid contract. John can appeal to the real estate department. No. There's no contract. No. The broker can mediate. No. 18. When contracting to buy a new home from a builder, the agreement usually calls for the earnest money to be what? To be deposited. The answer is C. To be deposited in the seller's business account. So when contracting to buy a new home from a builder, the agreement usually calls for the earnest money to be deposited in the seller's business account. So is it deposit in escrow? No. Deposit in the broker's trust account? No. Deposit it in escrow within 48 hours of acceptance? No. Deposited in the seller's business account. This is because it is a new home from a builder. So, I mean, typically we deposit in escrow and you got like 48 hours to do that. But on a new home build, it's usually within the builder's business account of the seller's business account. Number 19, T made an offer to buy a property, which the seller accepted. The acceptance was communicated to T by phone, but T died before receiving the contract. In this situation, what happens? Answer is C. T's death voided the contract. So because T died, the contract is null and void. So again, T's death voided the contract. So T made an offer to buy a property, which the seller accepted. The acceptance was communicated to T by phone. Right? It wasn't written yet. It was just verbal. But T died before receiving the contract. right? So he couldn't sign. It was just verbal. So what would happen with the contract? It would be voided. T's death voided the contract because they can't sign it, right? So that's why it's null and void. So you make the offer. The seller accepted it, but it was only by phone, and the T died because before receiving the contract to sign. So A says there is an enforceable contract. No, T's heirs are bound to the agreement. No, T's death voided the contract. Yes. The heirs must void the contract within 30 days. No. The seller of a property that has been listed for many months is out of town for an extended period of time, and a full price offer is made by a buyer. The listing broker, B, we said may not accept the offer. All right, so we finished unit 15. Now we're going to go on to unit 16.